All right, we're ready to kick off the session.
Glenda, you're muted.
There we go. Can you hear me now?
Yes.
Okay, thank you. My name is Glenda Moyer. I'm with the Fair Housing Council of Oregon. I'm joined today by my supervisor, Shal Reuter. Super excited to be here. I'll give you a little bit of my background. I spent 14 years in law enforcement. 6 of those years were on parole and probation. So I saw firsthand how people with criminal histories had a hard time getting into housing and how that was a barrier for them. So I'm super excited to be here today to share this information with you. I did notice there were some people from parole and probation on here, which I'm also very excited about. With that stated, we'll go ahead and just start. So today I'm going to be speaking about eliminating a barrier or many barriers in some cases. It's fair housing and advocacy for housing applicants with criminal histories. We're going to cover a quick recap on the Fair Housing Act and protected classes, Oregon's history of discrimination and how that affects barriers to housing, criminal history as a barrier, disability of alcohol and drug addiction and how that applies to fair housing laws, and disparate impact on people with criminal history. So we're just going to discuss the federal protected classes today to save time. The first 4 protected classes under the Fair Housing Act that were enacted in 1968 are race, color, national origin, and religion. And through the 70s, during the women's movement, sex was added. And more recently to that, the protection of domestic violence survivors and sexual orientation and gender identity was added under the protected class of sex. Familial status, that's families with children and disability, was added in the 1980s. So today we're going to be focusing specifically on disability and how that applies to people with criminal histories and reasonable accommodation. But first, we're going to cover Oregon's history of discrimination. I think it's important to set a foundation of how Oregon got to where it is today in regards to the fair housing laws and disparate impact on certain groups of people. So with that stated, many don't know that African Americans were excluded from living in Oregon, in the Oregon Territory, and punished by lash laws. At the time the Oregon Trail was in effect and people were moving to the Oregon Territory to claim property, the Oregon Territory didn't want to be known as a slave state or a slave territory. So they didn't permit slavery, but they excluded people of color, specifically Black people, from going on the Oregon Trail to claim the property in the Oregon Territory. Many do not realize that Oregon had the largest per capita of the KKK in the 1920s. And this is due to a few reasons. One of those reasons is that directly after World War I, our soldiers were coming back from war, and there was a negative view on immigrants in the United States at that time. Right about the same time, the first major motion picture came out, a 3-hour-long film. It was a silent film called The Birth of a Nation. This specific film glorified the KKK. It showed them as being heroes. It also glorified the Old South and depicted Black people or Black slaves in general as being kind of foolish, okay? Which was kind of a prime arena for the KKK to step in and use this film as a way to recruit for the KKK. They showed outdoor viewing, so families showed up, would view this. And if you're thinking about this in correlation with, as Oregon as a state, okay, where we're not allowing Black people to live here, it really was prime area for the KKK to step in and kind of expand its fingers out throughout Oregon. So with that stated, in the 1920s, Oregon had over 35,000 members of the KKK in Oregon. There was 58 claverns and approximately 7 provisional groups. Those provisional groups weren't necessarily sworn in members of the KKK, but they were radical groups that aligned themselves with the KKK. In addition to that, African Americans, Chinese, and Japanese weren't allowed to own real estate throughout different parts of history in Oregon. Many may remember the internment camps that the Japanese were put into after World War II. Their property was taken from them. Their businesses were taken from them. In addition to that, you can still see today in housing deeds that have been transferred. However, they, those deeds, with the verbiage they have in them, that might be discriminatory, cannot be followed upon. But with that stated, in housing deeds today, you can still see verbiage that is very specific in regards to who can own or occupy the premises. The specific one was signed in 1926. To follow up with that, there were sundown laws that persisted up through the mid-60s. Many communities in Oregon had laws that did not allow people of color to be outside after dark. If that was the case, they'd be ran out of town, or other violent things could happen to them. Because of these types of sundown laws, and it wasn't safe for people of color to be traveling, Victor Green made the Green Book, which is a book that he printed for three decades. The first one was published in 1936. It listed many different cities throughout the United States and areas that were safe for people of color to go to within those cities. So as you can see here, and this is the 1949 edition, in Portland, there's hotels listed, restaurants, beauty parlors, barbershops, nightclubs, roadhouses, taxis. So these are places that people could frequent and go to and feel safe doing so. So through the civil rights movement in the 1960s, I think many people don't realize the Fair Housing Act was the hardest piece of civil rights legislation to pass. It was initially part of the original Civil Rights Act. However, it was pulled out in 1964 and was not added to it. It wasn't until Dr. Martin Luther King Jr. was assassinated 1 week after, as a matter of fact, that President Johnson pled with Congress to pass the Fair Housing Act to quell civil unrest that was happening throughout the United States. So with that, I think I mentioned earlier that the women's movement added sex in the 70s, and families with children and disabilities were added in 1988. We're going to move on to other issues in regards to history in Oregon. And this is not just Oregon. Redlining happened all over the nation, okay? Redlining, if many of you don't know, is a jurisdictionally, it's literally on maps in red where Black people can reside, okay? So redlining and its consequences have denied socioeconomic mobility to the inhabitants of underserved neighborhoods, which plays a role in increased crime. Gang violence and crime, specifically robbery and assault, have trended upward over the years since redlining began. So as we can see this now, redlining literally put people of color in a specific location to live, prevented them from having access to living wage jobs. They were farther away from those areas, put them in unhealthy living situations because they were usually closer to areas that had industry, freeways, that kind of environment. And because they weren't unable to get living wage jobs, or there was very few jobs to be had in those areas, this is where the crime began, in those specific areas. With that stated, it also didn't provide the Black community or people of color with the opportunity to purchase homes, which would give them wealth. So even if you're redlining, in the situation, real estate agents weren't showing houses in other areas outside those red line districts. Lenders weren't lending money to people of color, specifically outside those red line districts. And even within the red line districts, they were not lending money to. So not only did redlining increase crime, okay, it was an effect of that, it also prevented people of color from gaining wealth. In the US, African Americans and Hispanics, and I use the word Hispanics, I don't want to be offensive to anybody, but that's the terminology that HUD uses in their criminal history guidance. So when I'm using it in this presentation, it's because it's the verbiage they're using. African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to their share of the general population. which causes criminal record-based barriers to housing for the people of color, and disproportionate impact on minority communities. So in the US, this is in 2014, non-Hispanic whites, they were about 62% of the population in the US at that time. And 30% of the prison population in the US was about 34% was non-Hispanic whites. African-Americans at that time were about 12% of the population. However, 36% of the prison population during 2014 was made up of African-Americans, very disproportionate in regards to the percentage of the population that they actually had. Hispanics were about 70% of the total population and at 22% of the prison population. In Oregon, disabilities are the most prevalent by far, okay, in regards to fair housing complaints to the Fair Housing Council of Oregon. The Fair Housing Council of Oregon sees about 50% of the contact they get regarding fair housing discrimination due to disability. After that is race, national origin, and familial status, and those protected classes make up about 15 to 20% of the contact we have in regards to discrimination in housing. So we're going to discuss disability because this has a direct correlation in regards to people with criminal history and how they can eliminate some barriers for themselves regarding application for housing. So the definition of the fair that HUD gives, okay, they give for disability is any physical or mental condition that substantially impairs a major life activity. And this can be walking, seeing, hearing, breathing, thinking, or caring for oneself. It is a very broad definition that pretty much can cover anything in regards to medical or physical disabilities, mental health disabilities, and developmental disabilities. The protected class of disability includes ongoing chronic medical conditions such as MS, cerebral palsy, schizophrenia, autism, seizure disorder, asthma, PTSD, ADD, depression, and anxiety. And those are just some examples. It's important to understand that addiction to alcohol and drugs, if it's not a current user of illegal drugs, are also considered protected under the protected class of disability. They fall under that disability class. It also includes a history of disability. So somebody who's been diagnosed with a disability years previous, that also is included and protected under the Fair Housing Act. It includes an assumption of disability. So people who are being treated differently by a landlord or a lender or a real estate agent, because that landlord, realtor, or lender think they have a disability, and those people, because they think it and they're treating them differently, even though they may not have that disability, that they are protected because the assumption is they have a disability and they're being treated differently because of that assumption. It should be noted that a housing provider can't discriminate based on disability. So if a housing provider, a lender, real estate agent is discriminating against somebody because of their disability, that does violate the fair housing law. The applicant or tenant must be able to follow the rental contract. So just know that disability can't be used as an excuse by somebody to not follow a rental contract. But they can't ask for a request in regards to that. So when they're requesting something due to their disability, that means a landlord may need to provide something extra or remove a barrier that could prevent that person from living there. So there's, in one way, there's a reasonable modification. Someone who has a disability can ask for a reasonable modification if they need a physical change to their rental unit, which is like maybe a ramp, grab bars in a shower, adapted bathrooms or kitchens, or they can ask for reasonable accommodation, which is an exception to a standard policy or practice or procedure that the landlord normally would follow. So a reasonable accommodation request can occur at any time. It can occur at application. It can occur while someone's residing in the rental unit or after receiving some kind of notice, whether that be a violation notice or an eviction notice. And there's no limit to the number of accommodations a resident can request. Each request is evaluated on its own merits. So if someone needs multiple requests at different times to their tenancy, just know they can ask for those, and the housing provider should be looking at those individually on their own merit. A reasonable accommodation request during application, this is where it gets into people who have criminal history in regards to how you can help advocate for them or how they can advocate for themselves. At application, a person needs to demonstrate what has changed. So normally what will happen is somebody who's got criminal history, somewhere in their past, something happened where, you know, they were arrested and convicted on a crime. But since that conviction, they may have had a shift or change in their behavior for the better, okay? And they have verification of that shift or change. So with that stated, maybe, you know, landlords in Oregon can look at a few different things in regards to a background check. They can look at rental history, criminal history, they can look at credit history and the amount of income someone makes, okay? To see if they qualify to live there in the rental unit. In this situation right here, an applicant can ask for a reasonable accommodation regarding their rental history. Here's an example of that. Maybe someone has an eviction related to addiction. Maybe they were arrested at their last rental unit due to criminal behavior, okay? And part of the rental contract states that no criminal behavior on the premises. So their landlord evicted them. So now they have this eviction on their record, okay? With that stated, if that addiction issue was related to something, a disability, for instance, okay? Maybe they were self-medicating for an undiagnosed mental health condition. If they can tie it to that, that's what's important here. And we'll get a little bit more into that in a bit. Another example for credit history, for instance, could be poor credit due to extended incarceration in county jail, and they lost their job. So if someone goes to county jail and they can't afford bail, okay, and they lost their job because they're in jail, and now they can't pay their bills, that could have a negative effect in regards to getting into housing. In addition to that, their criminal history. Maybe they have an assault charge related to previously undiagnosed mental health issue. So rental barriers that may be related to disability. These are just some examples I'm going to share with you. When you're discussing with folks, when you're working with them to get into housing, it's important to know their criminal history and all of it, okay? And why that information's on, you know, why those convictions are on their criminal history. So sometimes you might see under, you know, someone who's had addiction issues, public indecency, or I'm sorry, public intoxication, assault, public indecency, resisting arrest, theft or burglary, possession, forgery or identity theft. Mental health, you might see some, you know, something a little bit different, not necessarily, but you could. Disorderly conduct, offensive littering, trespass, theft, assault, possession because they're self-medicating, or stalking. And someone with a developmental disability might be an unwitting accomplice in a crime due to their vulnerability. They might have just been forced to do something because they were vulnerable. It needs to be noted that the person who's applying for housing needs to be able to demonstrate or verify that there's been a shift or change in their behavior, okay? They need to provide verification of that shift or change. And the applicant still needs to be able to meet requirements of the rental agreement. I'll say that a few more times probably through this presentation. It's important to know that disability can't be used as an excuse not to follow the rental contract. So requesting a reasonable accommodation. Okay, so there's three things that must be in play. Does the person have a disability? Is the request related to that disability? And is the request necessary for equal access and or equal enjoyment of the rental unit? If all of these are yes, then a reasonable accommodation can be requested. So this includes being able to meet the requirements of the rental agreement. Again, I put that on there because I think it's important for people to understand that. So requesting a reasonable accommodation or reasonable modification request. So it's always initiated by the applicant or the individual living in housing, okay? Best if done in writing. That leaves a paper trail. That way there's no question in regards to what the person was asking for, when they asked for it. And the landlord should respond within a timely manner. Okay, so when someone's asking for reasonable accommodation, it can't be done verbally or through a family member or friend, but it's best if done in writing. It needs to identify, they need to identify in their request as a reasonable accommodation or a reasonable modification and state is related to a disability. It's important that the landlord knows that their request is due to their disability. They must have verification letters, and we'll cover those here in a second. Advocates, you guys can help anybody you're working with to get into housing who might have criminal history or other barriers to get into history or get into housing. Role play with them or create a plan with them to help them feel more at ease with this process. It can be that the process can be disturbing to some, okay? It can be stressful, especially if you're dealing with somebody who really doesn't know how to communicate very well. So it's very important that as you as an advocate, help the people that you're working with that have criminal history kind of role play through this process in regards to how they're going to talk, how they're going to talk to their landlord, what they're going to say to their landlord, and what verification items or letters they're going to have to give to the landlord with the reasonable accommodation request. Verifiers of disability must be qualified individuals. It can't be mom or grandma because they're always going to say wonderful things about, you know, their son or daughter or child. So it can be, but not limited to, doctors, nurses, physician's assistants, nurse practitioners, counselors, psychiatrists, psychologists, drug and alcohol counselor, therapists, social workers, sponsors, pastors or priests, etc. It's someone who's working with that individual, knows that individual, and understands the need for the reasonable accommodation request. The verifier does not have to disclose the type of disability, and nor should they, or the physical benefits from the request, okay, for the reasonable accommodation or modification request. The verifier is basically stating this person has a disability that qualifies under the Fair Housing Act. They need whatever they're asking for equal access and enjoyment of the unit. So just know that whoever's writing the verification letter should not be giving out too much information about the specific disability to the housing provider. But there must be a connection between the reasonable accommodation or modification request and the disability. That whole thing, there's got to be connection with it. So examples of documents that may verify disability can include, but are not limited to, a letter from a qualified individual. I just spoke to you about who can do that. A graduation certificate from a drug and alcohol program. At application, documentation showing a change in behavior that was related to disability. Okay, so let's give you an example of this so you're very clear on this. You have somebody who's got criminal history, okay? They are applying for housing, but they are no longer the person they were when they got their conviction, okay, years ago. It might be 2 years ago, it might be 5 years ago, it might be 6 months ago. They've completed a drug and alcohol program successfully. Maybe they're engaging in community support groups on a weekly basis in their community. They might even be working full-time. They have gainful employment. They are going to church. They might even be part of another organization they volunteer their time in. Whatever it is they've done or that they're doing now, get verification from all of it. Provide at the time of application to a landlord to show this person's no longer the same person they were back then, okay? If they're asking for reasonable accommodation due to disability, which they would have to be, they would have to also show that there's a disability. With that stated, a graduation certificate from a drug and alcohol program would be verification of a disability because alcohol and drug use, if the person's not right now using, okay, that's in their past, that's considered a disability under the fair housing laws. So credit score, gainful employment letter from pastor, priest, other certifications of completion, okay? Housing provider can't require someone to use their reasonable accommodation or reasonable modification forms. They can have them available, but they can't require someone to use them, It's always nice to have available. It makes it easier, I think, for a lot of people. But if someone were to get a letter from their doctor or just hand write out their request, they can't then in turn say, you have to use my form. And verification can be delivered either by the tenant or applicant, mail, email, or faxed, and can come directly from the applicant or directly from the provider. It doesn't really matter who delivers it. It could even come from the person who's assisting them to get into housing. The landlord can't deny someone dropping off a reasonable accommodation request for somebody. It's important to note that all requests must be considered, but the request must be reasonable. So reasonable doesn't mean that the housing provider is second guessing the resident's doctor or therapist. If the letter from the therapist or the doctor or the provider states this person has a disability that qualifies them as being disabled under the Fair Housing Act, and they need whatever it is they're asking for, they need you, landlord, to look past their criminal history due to their disability, okay, for equal access and enjoyment of the housing. That's all they have to state. What the housing provider needs to be looking at is how it impacts them, okay? What's the impact on the housing provider? 4 things they can look at. Is it too costly for them? If someone's asking for a reasonable accommodation request and the housing provider is like, I got to deny it, it's just too costly for me to provide this to you or to do this for you, they're going to be able to open their books and show where they don't have the money to provide that request. Is it an undue burden to the housing provider? Maybe it's taking up too much of their time, okay? Maybe they spent already 8 hours doing some research on a reasonable accommodation request and they just can no longer do it any further. That could be a reason to deny if it's undue burden. Part of the housing provider's job description. Is the request not within the housing provider's job description? Maybe someone's asking them to pick up after their assistance animal, which would not necessarily be something within the job description of the landlord. And the 4th thing, is it a threat to the property or threat to others? So when you're dealing with someone with criminal history, just know there might be a few crimes that a landlord is listed under their policies and procedures that they just will not rent to, okay? And those usually include, I'm not going to say they're always this way, those usually will include registered sex offenders, arson, and manufacturing delivery of methamphetamine. If you are dealing with somebody or working with somebody who has any of those convictions or would fit into those categories, as long as they are able to show that they have had a shift or change in their behavior through therapy, through counseling, whatever it may be, please still assist that person with asking for that reasonable accommodation, because you never know when a landlord will give them that chance. So just know that's not always a flat no for those landlords, but if they are able to show there's that shift or change in their behavior through verification, that's always best. A housing provider should only ask questions related to screening criteria and or rental agreement, not the disability. So when someone's applying for housing and asking for that reasonable accommodation due to their criminal history, they may have to provide a little bit more information about their criminal history, but the disability that's connected to it, the housing provider cannot ask details about that disability. The housing provider should keep information about someone's disability confidential. They should not be sharing that with other people. They also should expect verification for the reasonable accommodation or the modification unless the disability is evident. So if someone's in a wheelchair asking the landlord to install a ramp, it's an evident disability. The landlord should never ask that person for verification of their disability. Anything that's not evident, that's considered a disability, the applicant or tenant should be ready to provide that verification to the landlord. Expect the applicant or tenant to show the connection between the disability and the reasonable accommodation or modification, and that it is needed for equal access and or enjoyment of the unit. A landlord can expect that. They need to know that's what it's for. And it keeps it very clear. There's no misunderstanding what the request is for if they know that information right there. And the housing provider should work with the tenant to find a reasonable alternative if denying a request. So if they are unable to accept a request, in this case, let's talk about some of the criminal history. At time of application, they provide a letter from their probation officer saying that the person's been on probation for 6 months, and for 6 months they've been compliant while on probation. The landlord may not believe that's enough for them to move forward and rent to them without further verification. They may want to know they've taken some programming classes or some classes that's got, gave them a different way of thinking. So maybe it was an alcohol and drug class or an MRT class or something. Those should also be with that letter from the probation officer or therapist or whoever it is. So just know that the landlord's denying a reasonable accommodation. They should come back and say, unfortunately, I don't believe you provided me with enough information for me to make this decision. Is there any other way you can show me verification of other things you've accomplished or something? They should be able to work with them in that way without just flat denying them. A housing provider should not ask questions about the nature of the disability, share information about a resident's disability with other residents, require a tenant or applicant to be examined by the housing provider's medical provider or mental health provider, okay? If you have a housing provider saying, you know what, I don't trust any doctors that are giving me a reasonable accommodation verification letter, I will only allow verification from my doctor. This tenant has, or this applicant must see my doctor in order for me to accept the letter. That's illegal, they can't do that. So require that the verifier report that the reasonable accommodation or modification is necessary to live independently. That term, that specific living independently is not needed and it should not be written in there at all. That can mean different things to different people. Or charge deposits for scooters, wheelchairs, caregivers, assistance animals, etc. These are all tools used by people with disabilities. They're looked at as tools, and landlords should not be charging deposits or extra rent or anything like that at all, charging nothing for this type of these things: scooters, wheelchairs, caregivers, assistance animals. So disparate impact in criminal history screening. So there's a disparate impact on race and national origin, okay? We've already discussed people of color are disproportionately convicted in the United States of crimes compared to non-Hispanic whites. So with that, when housing providers have rules and policies in place that might say we don't rent to people who've had person-to-person crimes, or they have a blanket statement, we don't rent to anybody who's had a felony arrest ever, okay? That literally would have a disparate impact, a negative impact on people of color. So because they tend to be convicted more often in regards to their population numbers, okay? Landlords can't say no arrests. Arrests are not convictions. Arrests can be pled down to lesser crimes. They can be dropped. Arrests are not convictions. So just know that if a landlord says no arrests, that can be problematic. If someone currently has an open case in court and they have not been adjudicated on that specific case, a landlord can say, I'm going to hold off renting to you, or I'm going to deny you right now because you do have an open case that's not been adjudicated on. They can say that. For felony conviction, they need to identify one that is dangerous to residents and or property. Again, I spoke of those three earlier, those specific convictions or those crimes. You might even have a landlord that throws another one in there. They might even say, we go back 3 years for criminal history. Any felony convictions in the last 3 years, we won't rent to you. That does not stop them from renting to people with criminal history in the last 3 years. You still would need to, if you're working with somebody who's got that criminal history that within that last 3 years, if they've made those appropriate changes in their life and they can prove that, please, please, please assist them with submitting that reasonable accommodation request due to their criminal history, okay? It's important that that happens because landlords should still take that in consideration, even if they have that rule 3 years, 5 years, 7 years, whatever they go back. Housing providers should consider when the conviction happened. So you might have someone who's been incarcerated for 10 years, who never did anything terrible while they were in prison. They didn't get new crimes. They've got a lot of programming while they're there. They took a lot of classes. They were working while they were in prison. They attended like church groups while they were in prison. They were really active in regards to like staying out of trouble and being proactive in regards to the recovery, and just being in a better spot, okay? With that stated, their last conviction was 10 years ago. They might actively be on some kind of supervision right now, but their last felony conviction was 10 years prior. And they can show, as long as they can show they did all these wonderful things while they were incarcerated, that could be verification enough for a house provider to rent to somebody. And again, they should consider certifications for rehabilitation. So let's talk about disparate impact and national origin. If a landlord requires a social security number, they must require them for everyone. They can't just go, okay, that person talks with an accent, or they look different, they have darker skin than I do, I'm gonna ask for a social security number. It's not the way it works. If they have that as part of their policy and their practices, they must do it for everybody across the board. However, there are other ways besides using a social security number to verify someone's criminal history, okay? Or their credit history. When someone's doing a criminal history, they're literally using name and date of birth. If they get multiple people coming up that could be, because they have near hits with name or date of birth, they could use a social security number to verify who it is. They don't need to. They don't have to do that. There are other ways to look to see who that person is and figure out exactly which person that's popping up is the actual person. If landlords refuse to use other ways to verify, is probably discriminatory, and especially if the applicant is a legal resident. So just know, if you're working with somebody getting into housing and you have a housing provider who's asking for that social security number, they best be doing it for all applicants. If you feel like the person you're working with is, maybe they're from the Latinx community, and you feel like they're being discriminated against because you helped somebody else 2 weeks prior who was white apply and no one ever asked for the social security number, but now they're asking this other individual for their social security number, it's probably discriminatory. It can be discriminatory, and that becomes a problem. All right, right now, does anybody have any questions?
There's no questions right now in the chat. So if you're okay with it, folks can just unmute and ask them.
There are actually, there's lots of questions in the chat, I think.
No.
Oh, no, but just people chatting. Okay, never mind. Anybody have any questions regarding this on how to assist people with criminal history to get into housing? Okay.
Hi, the question that I asked in the chat was about people who have a disability and a criminal history, but their criminal history isn't related to their disability. And someone responded, it's something to do with individualized assessment, but I don't know what that is.
Yeah, so what can happen is if someone's got criminal history and they do have a disability or they don't have a disability, no matter what, their criminal history had nothing to do with their disability, okay? They can ask the landlord basically to look past their criminal history, okay, not due to a disability. They wouldn't be asking for a reasonable accommodation, okay? This is like an individual assessment, like you said, where they're gonna offer basically the same thing to the housing provider. They're gonna offer all the verification they have in regards to completed programs they may have taken, letter from the employer. I'm just giving you an examples of what they could do. Letter from their pastor or priest. They might even have letters from an agency they've been volunteering at. Whatever it is they can gather to show that there's been a shift or change in their behavior, that they can provide that and ask the landlord to consider them for, to get into housing, because they're no longer that same person. They've changed their behavior. They made a shift in their behavior. Does that make sense?
Yeah, thank you.
They literally would not be asking for the reasonable accommodation. The reasonable accommodation, it's a little bit more sticky, because if someone denies a reasonable accommodation and they've provided that the person applying has provided all this information, that's wonderful information, and the housing provider still denies them, there's a possibility that that housing provider is discriminating against them, okay? Whereas if someone's asking for the landlord to look past their criminal history and there's not a disability attached to it, literally there might not be discriminatory, there might not be discrimination happening there if they denied, if that makes sense. There's a little bit different that way.
Hey, Glenda, we have a question from Travis Small, whose hand is up, and then afterwards there's a question in the chat that I'll read to you.
Okay, go ahead, Travis.
Hi, so I guess kind of a tricky question, because I can definitely be sympathetic to reasons why there would not be, but for properties in the Portland area or even outside of the city, are there any comprehensive listings for apartments where they're willing to look past sex offender charges? Because that is a difficult population, in my experience, to house. I used to work for TPI. I know of a couple of spots where that used to be the case, but is there any way of making that search easier?
Okay, so this is the deal. I'm going to give you some information, and it's not necessarily information that is printed anywhere. It's just something that you can do if you have the time, because it's going to be a little time consuming. You can literally contact the state police and ask them for a list of all sex offenders that are in your area and addresses. It might cost you a little bit of money. They can send you that hard copy or email it to you, however they do it, I'm not sure. And from there, you can go to your county assessor office website and look up those addresses and find out who owns that home. Okay, and you can start contacting homeowners at that point in time. It might be that you come across a housing provider who's willing to work their second chance, basically, housing providers. But unfortunately, I don't know of any list that's been put together unless there's somebody in this room right now that's what, sitting here with us that has that list or knows of how to get the list of housing providers in the Portland area or surrounding area that do second chance housing for people.
Yeah, what I'll say is that I don't know of any lists. Nobody has those lists, but I know that in certain areas of the state, sometimes the information is actually online of where registered sex offenders live. So for example, in Portland, you can actually just look that up online so you can see where people are living and then do that reverse search that Glenda's talking about.
Yeah, and with that stated though, just know, I am gonna add this with that, Shal, that's great information. The online resource actually are for predatory, sexually violent, and offenders that might be on some kind of mental health hold. Those are the only offenders you'll see online. So, but honestly, if I can just label it this way, probably the worst of the worst. And so if people are renting to them, those are probably some landlords you want to seek.
Okay, great. Thank you. That was great information.
Hey, Glenda, so the question we have in the chat comes from Ben Redmond's Habitat for Humanity. What do you think needs to change or would be more helpful to those with criminal histories to get into housing?
I wish there was some kind of class that could be offered, and I know off and on there has been, I think, but I wish there was some kind of class that could be offered through the probation offices, through the Department of Corrections, in regards to teaching people how to advocate for themselves when it comes to their criminal history and housing. Anybody who works with somebody who has been, has that criminal history knows that housing is a stabilizing factor for them. One of those things that if they don't have stable housing, the odds go up that they're going to commit more crimes and the recidivism rate goes up. So I wish that somehow, some way, some shape, some form, that this information was accessible to folks who were not only incarcerated, but also working actively with a probation officer.
And then I also have something to add to that as well. So in addition to what Glenda said, one of the things that we know is that if somebody has not reoffended in the same way in an 8-year period, that they're actually just as safe as the rest of the population. Mm-hmm. So, with that information that we have, it would make a lot of sense then if there were landlord-tenant laws in place then that specified how long landlords are able to go back. Because with that information, an 8-year look back period should actually be sufficient to figure out if somebody is a risk or not. So it will be interesting to see what happens. I know that there's certain ordinances in certain areas of the state that are starting to reflect that. So for example, in Portland, there's the FAIR ordinance, which is specifying that landlords have to screen differently and takes that kind of information into account in regards to criminal history. So it'll be really interesting to see if we see the housing industry nationwide start to follow suit with this. That's the only thing I had to offer or to add to that.
Thanks, Shile. One more thing you may want to consider, you may want to reach out to housing providers, property management companies, other housing providers that you know of, and find out if they're willing to work with you or your agency, however that may look, in providing housing to and I'll say the word offenders, okay, people who are actively on supervision and or have a criminal history that would make them a little bit, higher risk in specific areas. Some offenders, some people on supervision, some people with criminal history are not allowed to live within certain areas of town, okay, where kids congregate kind of. I'm not sure, I'm sure PO can answer that in regards to what that looks like. I don't know if it's individual in regards to each person or if there's a set distance that the state requires. But if you're working with housing providers and say, hey, if you have a rental that pops up in an area that's within, more than 1,000 feet from a park, a school, or a place where kids congregate, would you be willing to rent to somebody who's got to register as a sex offender? They might be willing to do that, knowing that, that's safer for the community that way. I mean, I would just reach out and ask these questions. You're not gonna, hurt anything if even they tell you no, but you might come across some landlords that literally are willing to say, you know what, I'll think about that. I think that might be a good strategy or something. I mean, I don't know. All right, any other questions?
No other questions in the chat, no other hands raised. So if you want to keep with the last few slides, go
Yeah,
for
I just
it.
got a couple more slides. Okay, so fair housing laws, how they're enforced here in Oregon. So most commonly, the Fair Housing Council of Oregon is contacted first, not always, but usually. Our enforcement team deals with over 2,000 contacts a year. And this is actually a great number, believe it or not. Our enforcement team resolves over 70% of the fair housing issues through advocacy. That's either contacting landlords directly, via phone, writing a letter, some kind of contact with the housing provider or insurance agent or lender, okay, or rental, real estate agent, whoever that person is that's violating the fair housing laws, and they're able to remedy the problem just by that contact. We do speak English and Spanish within our agency, and we use a language bank that assists us with communicating with other people, with people who speak from other languages other than Spanish or English. There's no income requirements getting services from the Fair Housing Council of Oregon. We're actually a nonprofit statewide civil rights organization, and it is our mission to eliminate housing discrimination through access of enforcement and education by promoting diversity, equity, and inclusion. So just know we don't charge for our services, and there's no income requirements to get our services. We can help, though, file a complaint with HUD and or the Oregon Civil Rights Division, which is the Bureau of Labor and Industry, which is known as BOLI here in Oregon. How that looks is there's an investigation that will happen if it doesn't get resolved in that 70%, okay, that I spoke of earlier. It's determined if the discrimination happened in a dwelling, it must be a dwelling. Did discrimination actually occur, okay? And they use investigation tools, whether that be using like a secret shopper to call or show up or fill out applications to see how landlords respond, and other tools they have at their disposal. And enforcers of fair housing violations that cannot be remedied can be BOLI, HUD, the State Attorney General's Office, U.S. Department of Justice, and or attorneys like Legal Aid Services, Oregon Law Center, civil rights attorneys, other private attorneys. They have a pool of them. The Fair Housing Council's enforcement team has a pool of them they use. And then there's outcomes. So we do list our outcomes, I want to say. I know BOLI does put their outcomes on their website. In addition to that, if you are working with somebody who you feel is being discriminated against, or they come to you and they feel like they're being discriminated against in housing, due to the protected class. We do have a hotline number you can call. It's either the 800 number or the 503 number as you see on the screen here. And that would be extension 2. Or you can email information@fhco.org or make contact with the Fair Housing Council of Oregon through our website. You go to www.fhco.org. At the very top of the screen, you'll see advocate contact and then another button that says contact. If you are an advocate and you're making contact with Fair Housing to ask questions because you don't know if it's really discrimination, or it's discrimination, but you just want to get the information to the Fair Housing Council of Oregon, you would click on the advocate contact. If the individual you're working with wants to file that themselves, they would go onto our website and just click contact. All right, and believe it or not, that went faster than I thought it was going to. We are done.
Yeah, so if anybody else has any questions, please feel free to raise your hand or just ask the questions or add them into chat and we can answer those questions. Please also take a moment just to fill out our evaluation. We really appreciate this. Our presence here is funded by specific grants that we hold, and our funders like to know how successful we are with doing these trainings. So please fill out that eval. It takes a minute to 2 minutes at most. So, and then any other questions, please just unmute yourself and ask. And thanks so much for being here. We really appreciate it.
Hi, Lois. How are you doing?
I'm good. Thank you, Glenda. How about you?
I'm good. Thank you for being here.
You're very welcome. It's always beneficial to listen to these webinars because I have a lot of clients that experience these issues. And it's always good to know how to advocate for them.
Absolutely. No, you're absolutely right. And I know with the population of folks that you deal with, disability is ranked right up there as number one, the issue with you. But then I know many of them probably do have criminal history. So hopefully you learned today.
A lot of them do. Yes. And one of my clients was turned away today. She's homeless, but she's turned away because she said that she had an income of $750.
Really?
Yeah. So, $750 isn't enough to pay for rent anywhere.
Exactly. Are you guys offering her a subsidy through your program?
Anybody with a disability can. I work one side of the program, or Jeff works another side. And my people that I work with have any disability other than what Jeff's has. Does that make sense?
Yep. No, I get it. I get it.
So I can work with people with all kinds of disabilities.
Got it.
But we don't have the funding on my side of the program.
Really?
Yes, absolutely. So certain disabilities get more funding than others.
Can I call you later when this is over?
Yes, you may.
Thank you.
Thank you, Glenda.
Yep. All right. If nobody has any other questions, I'm going to go ahead. Yeah, and welcome, Jeremy. Welcome to Oregon. I'm going to go ahead and log off, but I don't want to leave if people have questions.
Yeah, I think we're winding down. So.
Okay. Well, thank you everybody for being here. Thank you both Housing Oregon and our federal supporters. We appreciate it very much that you allowed us to present this information today. And everybody have a wonderful day.